Good afternoon, everybody, and welcome to our series. And today for a special presentation on what is a fiduciary and why is hiring a licensed fiduciary beneficial with Estate Attorney Heidi Klippel. Today's session is actually the kickoff of our spring series of senior seminars. And this series is meant for everybody on this call, for this very special group of people, and that is for everybody who's getting older. So if you're not getting older, you don't belong on this call. But if you are, there are a number of issues that come up that we all have to face as we age. And one of them is the question of fiduciary. But I do want to mention we have several others that are coming up very soon. Social Security 101 with Ryan Hislop on March 19th. Our very important Medicare seminar on March 22nd. And then the pros and cons of hiring a fiduciary rather than having a family member as a trustee. That's sort of part two to this presentation, again with Heidi on Wednesday, March 24th, followed by Advanced Social Security with Ryan Hislop. So if you haven't done Social Security yet, I highly recommend that you sign up for one of those seminars. We are joined today by Heidi Klippel. She is a San Diego native. She attended the University of San Diego, where she graduated magna cum laude with a bachelor's in political science. She always knew she wanted to be an attorney. So Heidi began working in law offices at the tender age of 14. After she graduated from USD, she went on to obtain her Juris Doctorate from the California Western School of Law and graduated in the top third of her class. During her time as a law student, Heidi concentrated her law studies in the area of estate planning, tax planning, and corporate business law. Heidi has been working closely with the UCSD Retirement Association for more than 10 years now as part of our group of what we call our select professional partners, the best and the brightest in each of their fields, who come and bring that information to our members on an informational basis. There's no sales at all involved in this presentation. Heidi will post her contact information. You see it there in that slide, but that's merely if anyone wants to contact her with additional questions. But we thank Heidi very much for her service to the UCSD Retirement Association. So Heidi, go ahead and get started. Thank you.
Well, thank you, Suzanne, and thank you everybody for spending time with me today. I'm here to talk about being a trustee and what that entails, and we're also going to talk about what your options are as far as whether it's preferred to bring on a private fiduciary or corporate trustee and or a family member. So generally speaking, when a person creates an estate plan in the state of California, there are two methods of choosing who you'd want to be your financial advocate if you were to lose capacity. One method is a document called the Durable Power of Attorney for Financial Affairs. And the purpose of a Durable Power of Attorney for Financial Affairs is if you were to become incapacitated, this document will identify who you trust to come in and be your financial advocate when you lack capacity to be your own advocate. Generally speaking, in California, with an estate plan, oftentimes people will also create a trust. And when you create a trust, you also nominate an individual called a successor trustee. So oftentimes when people do an estate plan through these two documents, the trust and the durable power of attorney, one of the most important decisions you're going to make is who you would entrust to be your financial advocate if you lost capacity. So what often happens is people will ask, what happens in the state of California if you don't have these documents in place and if you were to lose capacity? So what happens in California is when you don't create these documents and the court doesn't know who you would want to choose to be your financial advocate, there is a court process called a conservatorship. So a conservatorship is a process that's under the supervision of the probate court, where a person can petition the probate court to be appointed your conservator if and when you were to lose your capacity. One of the downsides to a conservatorship is you don't know who amongst your extended family and close friends might be the individual petitioning the court to do that for you. So in all of our families and circles of friends, all of us have people that are very financially astute, and all of us know people, with all due respect, that aren't the most financially astute. And money is very subjective. How each of us invest our money, how each of us enjoy our money varies from individual to individual. So it's very important, in my opinion, to have a trust and a durable power of attorney so that you have the ability to choose who these individuals are going to be. So when a person doesn't have a trust or a durable power of attorney and a conservatorship occurs, not only do you not have the power to pick and choose who these individuals are, but a conservatorship is also a public process. So if I were to be hit by a drunk driver and if I didn't have these documents in order, anybody could go down to the San Diego probate court and pull my file and see who is petitioning to be my financial advocate. And all of my financial information would also be made available through that public file. So then the question becomes, who would be good choices and what do these individuals actually do? So if I were to become incapacitated and if I have a trust and a durable power of attorney, while I'm alive, this individual's primary job is to step into my shoes and manage my financial affairs in the same or similar manner that I would if I had capacity. So generally speaking, if I were to lose capacity, when I have a document called a trust, one of the things you do with the trust is you title certain assets into that trust, like your real property, your taxable investments, your bank accounts, checking accounts. All of those types of assets end up being titled in the trust. So metaphorically, you want to think of your trust like a bucket. So when you create a trust, the second part of putting a trust in place is changing the title of your assets so that they're in the name of the trust. And I only mention this because I want to explain one very big nuance between a trustee and a durable power of attorney. So when you create a trust, the individuals that you nominate in your trust have your permission to manage the assets that are titled in the name of the trust. So if I were hit by a drunk driver and if my husband and I were refinancing our house is titled in the name of our trust. So if I lacked capacity to sign my own signature on those refinance documents, my trust would give my husband my permission to step into my shoes and sign my name on those documents. If I didn't have a trust in place, then the durable power of attorney would give my husband my permission to deal with all of my financial transactions that are outside of my trust. So generally speaking, if I were to be hit by a drunk driver, and now let's say it's April 15th and it's time to file our tax return, my husband needs my contractual permission to file and sign my name on our marital tax return. And that is what a durable power of attorney would give him permission to do. If we didn't have the trust and the durable power of attorney, and even though we're legally married, the only way my husband would have the ability to sign my name on a refinance document or on a tax return is by petitioning the court to become my conservator. So one really important thing to understand is when a person loses capacity, how a person manages assets is going to depend on how an individual asset is titled. So when you have an asset like a house that's titled in the name of a trust, the person would be acting in their capacity as the trustee of your trust. Whereas if you had an asset like a vehicle that's titled in your individual name, if you lost capacity, then it's the durable power of attorney that would give that person the power and authority to deal with all of your financial affairs that are outside of your trust, which would include the car. So in my previous example, if I were hit by a drunk driver, and let's say my car needed to be sold, it's the durable power of attorney because the car is titled in my individual name that would give my husband my permission to step into my shoes and sell that vehicle. So generally speaking, when people need to have a financial advocate, it's typically going to happen during a time of incapacity. So if I were to be diagnosed with Alzheimer's, for example, as that illness progresses, eventually in time, there's probably going to become a point where I'm no longer able to be my own financial advocate. And that is often when these documents are written to spring into effect. But sometimes I've had clients who have jobs outside of the country, and they might go ahead and voluntarily give powers over their financial affairs effective immediately, just because they are going to no longer be physically present in the United States to manage their own finances. So you can also have these document give powers while you're alive and you have capacity. It's honestly not that often that I write documents that way, but sometimes I'll have a client who's maybe in their 90s, with all due respect, and maybe their physical health is declining, or possibly their mental health is starting to decline. And they might want to update their documents so that their trustee comes on and has their permission to start helping them manage their assets while they still have the capacity to teach their loved ones about their financial affairs. So I will have oftentimes clients, and it doesn't necessarily have to be my senior clients. Sometimes I have clients that are diagnosed with a terminal illness. So they want to update their estate plan so that they can start teaching their loved ones while they have the ability and the capacity about their finances. So if they lost their capacity or passed away, they've got somebody in place who's familiar with their assets, with their debts, how they pay their bills, what bills they have, their logins, their passwords, and all of that information that you would need to take over the management of somebody's finances. So then the question becomes, what does this really look like? So let's say I'm hit by a drunk driver and I'm in the hospital and I lack capacity. I have a durable power of attorney and a trust that would give my husband my permission to deal with my financial affairs if and when I lost my capacity. So the first thing my husband would need to do to take over the full powers on my behalf is he'd need to talk to my doctors and have my doctors sign off that in their medical opinion, they believe that I lack the capacity to manage my financial affairs. Once he gets two separate statements from two separate physicians stating in the physician's opinion that I lack the capacity to manage my financial affairs, that's when the documents give my husband my full permission to take over the management of those assets. So if that happened, let's say yesterday, to not jinx anything, what that would look like for me is my husband would be able to make the car payment on my car. He'd be able to continue to make the car insurance payments on my car. When it came time to pay our property taxes on our house, he could write a check from our joint account and make that payment. So one really important part of naming a successor trustee and durable power of attorney is you do want to nominate somebody that is similarly minded to you, that is responsible, that ideally is good with money, that is honest, transparent, and trustworthy, because oftentimes these individuals will come into play if and when you do lose your capacity. With all due respect, is when you're at your most vulnerable. So picking the right people is really important. So oftentimes people will say, who do I pick? So I would say probably in the 20 years of practicing estate planning law, I would say probably 85% of my clients will nominate their family. It's not uncommon for people to nominate their adult children to be their successor trustee and durable power of attorney, but you have to have the right family situation. If you've got a situation where maybe you've got two children, and let's say they've always been a bit competitive and there's sibling rivalry, or maybe you've got the dynamic where one child thinks that you favored the other more than them, and there's a disconnect as far as that goes. Sometimes naming your adult children isn't always the best thing to do. And sometimes people don't want to put that burden on their adult children because maybe their adult children are raising their own kids and working full time. So every different family has a different dynamic and situation. So if you don't have the ability to name adult children as your successor trustee and or durable power of attorney, then the question becomes, who's your next best choice? And oftentimes I'll encourage people to look at their extended family. Maybe you've got a brother or sister that could be your successor trustee, or maybe your mom and dad are able to be your successor trustee. And one important thing to note is oftentimes people will say, well, gosh, Heidi, I'd love to have my mom and dad as my successor trustee, but they're 25, 20 years older than I am. And I'm afraid that by the time I lack capacity, they might lack capacity. So one really important thing to understand is whenever you create these documents, they are meant to be reviewed and updated about every 8 to 10 years. And honestly, the number one change people make to their estate plan is updating and changing their nominations for successor trustees. And that's because relationships change, situations change, people's health and capacity changes. So my best advice to clients when making the decision as to who is the best choice to assume these roles is make these decisions as though something might happen in the next 8 to 10 years. Because chances are in the next 8 to 10 years, you will update these documents. And part of updating these documents is reviewing the designations and updating them. I also want to mention that all of these documents have language in them that if any of the individuals you do nominate, if they were later to lose their capacity, they are no longer an eligible person to come in and be your advocate. So if my trust and durable power of attorney, for example, had my mom as my successor trustee, and if my mom had a capacity issue where she was diagnosed as lacking capacity, then she's automatically by the law no longer eligible to act on my behalf. So estate planning documents do anticipate the possibility of a person named no longer having the capacity, at which time when they don't have the capacity, they're no longer eligible to come on and be your advocate. I have a client just this morning, we were doing an estate plan intake meeting and she wanted her son-in-law to be her successor trustee. But her concern was, what if her son-in-law are no longer married at the time that these documents spring into effect? So one of the things that we can always do in drafting these documents is we can anticipate possible future contingencies. So I asked her if she wanted me to include language in her documents that would say that if her son-in-law was no longer her son-in-law at the time of acceptance, or if at any time while he was acting as her successor trustee and durable power of attorney, if him and his wife or daughter were to become divorced or legally separated, at that point in time, he would no longer be eligible to continue to act as her durable power of attorney. So documents can also be written to anticipate future contingencies. I had another client who really wanted his mom as his successor trustee and durable power of attorney. But he was afraid that if he didn't get around to updating these documents, because he admitted that he was a procrastinator, he said, chances are, Heidi, you're saying I should update these documents in 8 to 10 years, but for me, I'll probably see you 20 years from now. He says, today and in the next 10 years, I want my mom as my successor trustee and durable power of attorney. But truth be told, in 15 years, it's probably not going to be good for her to still be in those documents. So what we did is we calculated what her age would be 15 years from now. And we had that as a contingency in his documents, that his mom would be his first choice, but only if she was under that certain age at the time of acceptance. And if she were in place and acting on his behalf when she did hit that age of, I can't recall if it was 75 or 85, then she would no longer be eligible to act and she would have to resign and turn it over to the next person listed. So you can write the documents to anticipate those types of contingencies. So then I've had people ask, what if I don't really have a good circle? What if I don't have a lot of viable options as far as extended family? You can nominate a close friend to be a successor trustee. I had a gentleman whose neighbor was like a daughter to him, and his family was all in another country, and he wanted her to be able to come in and be his financial advocate if and when he lost capacity. And he had a conversation with her, asked her if she was comfortable. She said she would be more than happy to be his trustee and durable power of attorney. So he had her come on. His documents is his first choice. So when you do these documents, you're not limited to naming blood relatives. You can name friends if you have people in your circle that are financially astute and are the type of people that you would trust in a situation to be your financial advocate. So now that takes me to fiduciaries and corporate trustees. I have a list of private fiduciaries that our firm has worked with that we have confidence in, the clients have given us very positive feedback about. The nuance between a private fiduciary and a corporate trustee is a private fiduciary is an individual who's not backed by a corporation, whereas a corporate trustee is a person who is backed by a corporation. So the majority of banks and financial institutions today have legal departments that have trust departments, and they are equipped now to come on and act as your trustee and or durable power of attorney. So if you bank at Wells Fargo has their own trust department, and they have people in place that are licensed and bonded trustees that you could name in these documents. It's not uncommon when you identify and name a corporate trustee that they will only act as your trustee after you pass away. So one downside of naming a corporate trustee on these documents is if you were to lose your capacity while you're alive, most corporate trustees do not want to step in and be your advocate while you're living. They only want to come in and be your trustee to administer your estate after you pass away. So oftentimes when people come in and say, I've got this really good relationship with Wells Fargo or Bank of America, and I really want them to be my trustee, which is totally fine, then I have to ask them to have a conversation with that corporate trustee to see if they would also be willing to act if and when they lost capacity. So sometimes these documents will nominate one list of people to be a trustee if a person lost capacity, and you'll have a separate list of people as trustees to administer the estate after a person passes away. Some corporations will be both your trustee while you're incapacitated and will be your trustee when you die. So one pro of having a corporation as a trustee is they are licensed and trained and bonded, and they have the benefit of a large corporation to back them. So sadly, if this corporate trustee did wrong by the beneficiaries, and if you wanted to take them into court for whatever reason, you have the corporation behind them with deep pockets that you can go after if you needed to. Whereas sadly, sometimes when you have a private fiduciary, sometimes these private fiduciaries, with all due respects, are, they're just a mom and pop, it's just a me, myself, and I. I had a client who was terminal. She had cancer. She had about 6 months to live. She had no living family, no siblings, no children, no spouse. So she interviewed a private fiduciary that she really liked. And she said that she wanted this person to be her first choice trustee and her first choice durable power of attorney. So I asked her, who would be your second choice if for whatever reason this first choice wasn't able and willing to act? And she looked at me kind of funny and she says, well, gosh, Heidi, when I talked to this private fiduciary, they told me that they're all I need, that I don't need anybody else. And I said, but my concern is, what if you were in the car with the private fiduciary and they were driving you to the doctor and you were both hit by a drunk driver? If you and your private fiduciary were both injured and both incapacitated, then these documents need to identify who your second choice would be. And she says, but Heidi, I don't think I need a second choice because this private fiduciary told me that she is all I need. And I said, well, then why don't you call the private fiduciary and ask her how we should address the possible situation, which granted, it may not be that possible, but anything's possible. I said, what if the two of you were both to lose capacity? What is her system and what is her plan as to who would come in and take over the advocacy of your finances? So she called me and she says, gosh, Heidi, I called her and she said, wow, I didn't even think about that. So then I called the private fiduciary and I said, look, with all due respect, you probably shouldn't be telling people that you're all they need because they always need to have a backup plan. So if you're looking at the pros and cons between a corporate trustee and a private fiduciary, one positive thing that a corporation has is they have the benefit of a corporation in place. So if the main trustee, for whatever reason, wasn't able to act, or if they were calling in sick, they're always going to have a backup trustee in place. Whereas a private fiduciary, if it's a mom and pop type of a situation where they're a solo practitioner, They may not have a company to back them, in which case you need to make sure that you've got a second and third choice listed on these documents. So if your first choice, for whatever reason, could no longer continue to advocate for you, you'd want to make sure that you've covered your basis and you've got a second choice and possibly a third choice. So going back, pros and cons. One thing that I don't necessarily love about a corporate trustee is, like most large corporations, they have employee turnover. So if you were to, let's say, go and interview the trust at the trustee department with Bank of America, whoever you interview today may not be the person in place in 5 to 10 years when your trustee needs to come in and take over the management of your assets. So one downside of a corporate trustee, in my opinion, is you don't necessarily know who that individual is going to be. Whereas when you name a private fiduciary, you've had the benefit of interviewing this person, you've had the benefit of talking to them about their process, about their fees, and you'll also have the ability to name your second and third choice so that you've got plenty of people in place. You can also do that whenever you nominate family and friends. No matter who you nominate, you always want a first, second, and third choice. Okay, I see Miss Jean has got a question. Jean, do you want to unmute yourself and ask your question?
Thank you. Is it possible to designate a family member as your successor trustee with the understanding that they probably would want to hire a fiduciary themselves to handle day-to-day, actions? And in that case, they would be in a position to know exactly what the situation is and who would be best able to handle the situation as it happens right then.
So Jean, thank you for that question, because honestly, you pretty much just summarized the whole point of my presentation today. And that is, if you want my brutally honest opinion, just from being around the block for 20 years and seeing trusts being administered by individuals, corporations, and private fiduciaries, I personally think that if you have family and or close friends that you trust, these documents always enable them to hire professionals to assist them with the trust administration process. And one nice thing about having somebody that's an individual in these roles is they can always resign if they needed to, and they can always hire people to help them. So it's not uncommon when people pass away that we get brought in to help guide the successor trustee in the administration of a trust, because honestly, most individuals don't always understand the processes involved in administering a trust. And that is something that these documents always allow the person nominated to do. They can hire professionals to assist them with their duties in managing a person's assets and administering a trust. And the person's estate who you're advocating for will pay that individual's fee. So you're not out of pocket if you want to bring on a private fiduciary to assist you, or even an attorney to assist you. But the nice thing about bringing on individuals is, let's say they brought on an attorney to help them, and let's say the attorney wasn't returning their calls or was proving difficult to work with, they can always fire that attorney and find somebody else. Whereas I had a trust one time that was being administered by a corporation, and granted, this was just one trust administration, but this corporation was just pretty useless. They weren't doing very much. They were dragging their feet. They weren't very responsive. And the only way that these beneficiaries could get the corporation to leave and step down was to take them into court. So that's another pro and con. Oftentimes corporate trustees don't voluntarily resign. So if there is a problem with a corporate trustee, you oftentimes have to hire a lawyer and pay the monies and go into court and have the judge hear your case, and the judge decides whether the corporate trustee is in breach of their fiduciary duties. It looks like there's another question and I can't see the name. So do you want to go ahead and unmute yourself? Things, and those are things I was going to cover, so I appreciate you jumping in. So let's first talk about compensation, because that's a really good point. So whenever you nominate a corporate trustee to act, they always are going to take what's called reasonable compensation, which under California law, reasonable compensation is computed as 1% of the net value of your assets if it's an individual trustee like you or I, whereas a corporate trustee is going to take 1% of the gross value of the assets. So if I have a trust and if I have Bank of America as my trustee, and let's say I have an age contingency in place where my kids don't inherit until they're 35, and let's say at the time of my death, both of my kids are age 30, which means now I've got a corporate trustee in place that will be in place for the next 5 years. Every year that that corporate trustee is in place, they are going to be authorized to take 1% of the gross value of the assets. So when you have younger beneficiaries as beneficiaries of your estate, sometimes having a corporate trustee can prove very expensive, because if I've got a newborn, which I don't, but let's say I did, and if my trust says that they inherit when they're 35 and I've got Bank of America in place as my corporate trustee and I die yesterday, that means for the next 35 years, Bank of America will be able to take 1% of the gross value of my estate, which is 35% of my kids' inheritance that's gone by just paying corporate trustee fees. Whereas if I named my sister as my trustee, who's an individual, one of the things that an estate planning attorney should talk to you about when you're doing an estate plan is, do you want to pay your trustee? And if so, how much? So another nuance between picking and choosing between a corporate trustee, a private fiduciary versus an individual is when you have a corporate trustee, their fee structure is to take the 1% of the gross value of the estate. When you name an individual, you get to decide how much money you're going to pay that individual. So you could pay the 1% if you wanted, or you could pay a lump sum. So I've seen people pay, maybe $5,000 the first year that the trustee is in place, because the first year is the transitional year, and that usually is going to involve the most amount of time and work to get all the systems in place. And then maybe you pay $2,500 each subsequent year. So you can always determine and specify in these documents what you're going to pay the individual. Private fiduciaries oftentimes will either take an hourly fee or they'll act like a corporation and take a percentage. So I've seen private fiduciaries, which with all due respect, who have never gone through law school and have no formal legal education, charge upwards of $500 an hour, which is crazy. I mean, I say it's crazy because I just think it's excessive. So one of the things you want to do is, if you are going to ask private fiduciaries and interview them to possibly take over these roles, always have the conversation about compensation, because I have met some very competent fiduciaries that charge $75 an hour. I have met some very competent fiduciaries who charge $175 an hour. And then there are private fiduciaries that charge $500 an hour, which $500 an hour, to be honest, is very excessive for that type of work. So when it comes to a fiduciary, you always want to ask the question about compensation, because they have the discretion to charge what they deem reasonable. And generally speaking, people are going to raise their fees on an annual basis, because the longer they've been acting as a private fiduciary and the more experience they have, generally speaking, the higher that hourly amount can be. If you're thinking about hiring a private fiduciary or even a corporate trustee, you should almost treat it like a job interview, in my opinion. I don't think it's a bad idea to ask them for names of clients that they've worked with, and talk with people that have worked with this individual or corporation and see what kind of an experience they have had. I mean, like with anything, even estate planning attorneys, there's some really good estate planning attorneys in San Diego County, and there's some really horrific estate planning attorneys in San Diego County. So word of mouth is generally a really good way of finding a private fiduciary or a corporate trustee. And I would always encourage you to get a list of a couple of names and interview them just like you would a prospective employee. Sorry, my mouth is dry. Do you guys have any other questions about that? It's not a bad way of structuring it. I mean, if you've got automatic bill pay in place, then if I was, let's say, a private fiduciary, and if you named me to manage your assets if you lost capacity, then I would have access to your bank accounts, and I would have access to making sure that those bills are being paid correctly. Luckily, with technology today, it's a lot easier now to have people step in and assume those roles, which, to be honest, it also makes it a lot easier to have people that are out of state assume those roles now, because it used to be that it was very helpful to have people in the proximity of where you live in these roles. But now, since so many people can manage their accounts online and they can set up automatic bill pay, If you wanted to have a family member or friend as your not as your private fiduciary, but as your durable power of attorney and trustee, if they lived out of state, that's not as problematic today as it used to be, because modern technology makes managing people's accounts from afar so much easier. So when it comes to picking a corporate trustee versus an individual versus a private fiduciary, you definitely want to interview these individuals. You also want to ask them, what is their game plan? How long do they plan on practicing? Do they have any plans of retirement? Because that's the other thing you're going to want to be mindful of, is you should revisit these documents about every 8 to 10 years. And you should always follow up with these individuals that you've put in place that are private fiduciaries and corporate trustees to make sure that they're still willing and able to do that job for you. Because sometimes, like with anything, if I name a private fiduciary as my first choice, but then they retire and I have no knowledge that they've retired, now I'm down one person in my documents who's not going to be able to advocate for me. So you always want to make sure that when you have private fiduciaries in place, that you're checking in with them, making sure that they're still acting as a private fiduciary. When it comes to corporations, sometimes corporations will offer these types of professional trustee services, and then over a period of time, some corporations have shut their trust departments down. So you could have banks that 10 years ago offered the services of professional trustee that today in 2021, they've stripped down that department and they don't offer that service anymore. So for any of you that have private fiduciaries in your estate planning documents or a corporate trustee, it's not a bad idea to put that on your calendar every 5 to 10 years as a reoccurring event to touch base with them and make sure that they're still in business and that they can help you. You asked earlier about licensing. It used to be that getting a license to be a private fiduciary was voluntary in the state of California. So 10 years ago, I was a little more skeptical about naming private fiduciaries because there really wasn't licensing in California, but now there is, which makes a lot of sense. You want to make sure if you do hire a private fiduciary that they are licensed and bonded. The purpose of a bond is if they were to do something wrong with your assets, you could always go after the bond to reimburse you or your family if they did breach any kind of a duty. So if you don't mind a quick story, I had a gentleman call me because his mom sadly was ill. She was in a coma and she had been sick for about 20 years. Her husband, while she was in a coma, had used her durable power of attorney to take all of their assets that they owned together, which was primarily various houses and commercial buildings, and he put those assets in his name or his girlfriend's name or his kids from his first marriage's name. So she was incapacitated. She's still alive. And he used these documents, which, mind you, he's acting in a fiduciary capacity, even though he is her lawful husband. His job was supposed to be to manage these assets for her benefit, pay her bills for her benefit. But instead, he used these documents to take the title of the assets out of her name and to put title in his own name and his kid's name and his girlfriend's name. Well, you can tell that this is a bad story because I wouldn't be sharing it with all of you, but he died suddenly of a heart attack, which I don't think anybody thought he would die first. I think everybody assumed she would die first. So he passed away. And then we found out after so her son, we petitioned the court for him to become her conservator so that he could make his mom's decisions. And because his mom was the decedent's closest living relative, she was named, we petitioned the court to put her in charge of administering the estate. And it wasn't until we opened up these processes that we realized that he never divorced his first wife who lived in Canada. So legally he was married to another person, not to her. And then the girlfriend had been on title and using assets for the last 20 years for things that she wasn't legally supposed to be using assets for. So my point of sharing this story with you is these documents can be abused, which is why you want to make sure when it comes to naming the people that you entrust, that you are, I mean, granted, this poor lady, she probably never would have thought in a million years that her husband would have taken these documents and taken title out of her name, but they were a second marriage, and she had 3 kids from her first marriage. So now I think we're 4 years out of litigation and probably $150,000 in fees, court costs, attorney fees, which is so sad. And we're finally almost now resolving the situation. So you do really want to take these decisions carefully and make sure that you are, staying on top of making sure you're making the right decisions. I had a client once who had 10 children, and she wanted me to name all 10 children acting unanimously as her durable power of attorney and trustees. And I was honest with her and said, I don't really think that's probably the most viable way of structuring these documents. And she said, but Heidi, I don't want to hurt my kids' feelings. I said, but out of 10 kids, you probably have one who's really good with money and knows how you deal with your money. That would probably be a really good first choice. And then we could have a second choice. And if you wanted to go 1 through 10, we could have 10 options: first choice, second choice, third choice. But she didn't want to do that. She wanted all 10 kids in place as her financial advocate. And then sadly, she passed away. And then her husband called and said, let's fix this. I don't want all 10 kids on here because I know that that's not going to work. So making the decision about who you would put in place to be your trustee and durable power of attorney, it's honestly, in my opinion, one of the most important decisions you're going to make when you put an estate plan in place. And to me, it's not about hurting feelings. It's really about making sure that the person that you entrust with this is good with money, is trustworthy. If it is a person who you don't know, they can always be required to post a bond. The only downside to having a bond be posted is oftentimes if you wanted to insure $100,000 worth of assets with a bond, the cost of the bond is around $7,500. So having a bond is a way of having like an insurance policy in place. So if your trustee does wrong by your beneficiaries, you can have the bond pay the beneficiaries for whatever monies the trustee has breached or absconded. The other thing that's tricky sometimes for clients is their family is in another country. And in the United States, you generally want to have your trustee and durable power of attorney be U.S. residents or U.S. citizens, because if they are U.S. residents and or U.S. citizens, then the United States would have jurisdiction over the individual. So if, let's say, I named my aunt to be my trustee, but she lived in another country, one of the things that a trustee does when they start advocating for you is they have to put the assets into their name and their capacity as your trustee and durable power of attorney, because that's how they have your permission and power to manage those assets. So if I had my aunt come on my trust as my durable power of attorney and trustee, and if she put all those assets in her name so she could manage those assets, but then she took those assets out of the country, if she wasn't a US resident or citizen, then the United States can't extradite her. So that's sometimes difficult for people too, is if they have family in another country, it's tricky to find individuals here in the United States that you know and trust. But one way of solving that issue is if you named a person who's not a US citizen or resident to act with a person who is a US resident or citizen, then the United States has jurisdiction over the second individual. So that's also a hiccup that comes into play sometimes for individuals, is when they have loved ones that are out of the country. So I'm sure there's more questions. Can I take another question?
Yes, please. So Jean Linder has her hand up, but I want to sneak in real quickly with a question. I know you've spoken to me about it, but why is it a bad idea to have 2 children equally as a trustee?
So I don't think it's always a bad idea. It really just depends on your 2 kids. So if you've got 2 kids who trust each other, communicate, and really get along, I think having 2 people sharing the job isn't necessarily the worst thing. Granted, sometimes I've seen situations where if you have 2 people sharing the job, sometimes one assumes that the other one's doing something that they're not actually doing, and it can delay the process because they just falsely assume that one's doing more than what they're actually doing. So they assume that they're further along in the process. But if you've got a situation where you have two individuals that know each other, trust each other, are trustworthy, communicative, having two people, especially brother and sister or siblings, sharing that job isn't a bad thing. My issue is sometimes people will put siblings in place that don't trust each other, and that can create a lot of problems. I had a client just pass away recently, and she named her daughter as her trustee with her grandson. And when my client passed away, the daughter called and said, I'm really uncomfortable because I don't like my nephew. And I said, well, here's the thing. The trust says the two of you can act together first. So you're her first choice. But if one of you step down or resign, then it's your brother who would come in and act with whichever one of you are willing to continue to act. And she says, but Heidi, I don't like my brother either. And I said, well, I'm sorry that you're not a fan of your nephew or your brother, but your mom was very meticulous in wanting to make sure that there were two people acting as co-trustees. So for most people, two sisters, co-trustees, adult children, not a problem. It's just you don't want to put people as co-trustees that are going to have a difficult time because they have personality issues.
Got it. And Jean Linder has her hand up. Jean?
This is from before, but I do have a follow-up question. You said that anybody you designate as a trustee can hire help at a later point. And I'm just wondering about the advantages and disadvantages of, say, trying to identify a fiduciary who could act in your incapacitation ahead of time versus designating a family member to do the same thing when that situation arises.
So I have clients that will bring an adult trustee, whether it's a child or a family member, on as a co-trustee and durable power of attorney effective immediately because they want to start teaching them about their financial affairs while they have capacity. If you write the documents that way, it's really between you and the co-trustee and durable power of attorney as to who's going to do what. I know plenty of private fiduciaries that have been brought on to act as a co-trustee even when a person has capacity for the same reason. They wanted to start teaching them while they had the ability and capacity about their finances. And then once the person was pretty much in place and was knowledgeable about how the finances were structured, they basically sat and waited until the person lost their capacity, and then they took everything over. So you can certainly bring a private fiduciary on as a co-trustee with powers effective immediately for the purpose of teaching them about your finances and how you manage everything. And then whether you keep them as a co-manager just so that you've got a second set of eyes, making sure that you're doing everything correctly, or whether you then have them wait on the sidelines until you lose your capacity and then they step back in and take it over. That's a conversation that you can have with the private fiduciary or corporate trustee or family member.
I don't think I made myself clear. It wasn't about having somebody take that position actively immediately, but to designate them as the fiduciary to take effect at the time of incapacitation. Is it better for me to do that now for some future incapacitation, or designate, say, a sibling who will choose somebody to help them out if I become incapacitated?
Got it. So generally speaking, when you write these documents, if you have capacity, you generally are going to write these documents to only give away these powers if and when you lose capacity. So oftentimes the documents only give these financial powers away if and when you lose your capacity. But all of these documents have language that allow whoever the person is to hire whatever resources they might need to help them in their job in administering your assets. So I have had clients that become a durable power of attorney and trustee for a loved one who lacks capacity, and they'll use that person's assets to hire and pay a CPA to make sure that the taxes are prepared and filed. I had a client who had a problem with two siblings that couldn't agree on how to distribute the tangible personal property. And the private fiduciary didn't want to be involved in that. So she brought in an attorney for the sole and limited purpose of being a mediator to help them figure out who was going to get the couch, the car, and the TV. So the documents always have language that allow the person who's in charge to bring on whatever type of professional assistance they need, whether it's a CPA, an attorney, or what have you.
So fortunately, Heidi, you are a youngster. You're going to be working for a long time. For those of us that have done our documents through you and have named a child or two to be the trustee, but know that they wish to name somebody and they wouldn't have a clue, is their first contact just to call your office when it comes down, and then you direct them from there?
So I don't put language in my documents that requires people to call me. I have seen attorneys that will put language in their documents that requires the trustee to call that specific attorney. I don't put that language in my documents because maybe your daughter has a relationship with somebody who she knows and trusts that she would rather work with. So your documents allow your loved ones to hire whomever they want. And if people call our office to help them, we're always happy to help. It's not uncommon for a family to call the attorney that helped prepare the documents because the attorney has had the ability of talking to their loved one about how they wanted things to go. But legally, the person named in the documents has discretion to hire whoever they want, unless the attorney that drafted the documents put language in there that requires that person to talk to that specific attorney.
But should the trustee contact your office, you have the lists of all the necessary support people that you can provide.
Absolutely. Absolutely. And honestly, I think people are surprised when they step into these roles as to how much is involved and required of them. So in California, when a person passes away and you're a trustee, there are certain legal things that you have to do before you can make distributions to beneficiaries. And I can't tell you how many times people have called our office and they'll say, you know, my mom died a week ago. We've already cashed out the assets. We've given this, and that away. And
wow.
I just can't, because one of the first things you have to do as a trustee is you have to notify the beneficiaries in writing and include specific language out of the California probate code. Because the very first thing that actually has to happen when a person dies is you have to open and close the statute of limitations for beneficiaries to contest the estate. So if you have a situation where a person dies and now a person agrees to be a trustee and they don't seek counsel, so they really don't know what the process involves, if they start liquidating assets and they give all, because I actually had it happen once where a client gave all these assets to all the siblings. And then he called me and I said, look, we really need to open up a statute of limitations for people to contest the estate. Because if you give all the assets away and somebody wants to contest, now you have no bucket of money to defend the estate or yourself. So sometimes people will call us after they've already started doing things, then we kind of have to fix things because there's steps that were missed.
Wow, very important to know. Okay, we have a question from Lynn Fieldkarsh. Unmute yourself, Lynn.